State of Kansas versus Brian Bailey, 112888. Counsel?
May it please the court, the defendant appellant Brian Bailey appears by and through counsel Kate Zichtema. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved. Thank you.
Oh, this is disconcerting, arguing to an empty chair. This case, I think it might be cursed. I think we're up to Bailey 5. It's been resentenced 3 times. And at this point, we're asking the court to consider the restitution orders in this case.
Ms. Zichtema, can I talk about the resentence 3 times phrase
Yes.
and what you just said? Seems there's a difference of opinion on exactly what happened that last time.
Well, when I prepared for the case, it took me an entire legal pad to write down all the momentous events in this case because it's been dismissed, refiled, tried, sentenced for the first time in 1989. A motion to modify was granted in 1991 to reverse and remand for resentencing based on disparity with the co-defendant. Then we have yet another motion to correct a legal sentence because the calculations for the sentencing guideline equivalencies back when they imposed the sentencing guidelines, and everybody had to have if you have a post-sentencing guideline case, your sentence would have been a 3A or whatever it ended up being that you had to calculate before you impose the indeterminate sentence for the pre-Kansas sentencing guidelines case. So the last sentencing in 1999 was to correct errors in the sentencing guideline calculations, which don't really impact the actual sentence imposed on my client because it is a pre-sentencing guidelines offense, so he has an indeterminate sentence. Right now he has 3 15 to life sentences that are consecutive and are also consecutive to a life sentence for the felony murder. So he has 3 ag robberies and a felony murder, all of which are consecutive and are consecutive to his Wyandotte County cases as well.
And those were not changed in the third outing, were they?
Correct.
All that happened was a computation that he's entitled to statutorily, but it did not change his sentence in any way.
Correct.
And even as that hearing began, there was no potential for his sentence to be changed in any way.
Correct. I don't believe the remand order on that issue in broaden the scope of the resentencing to crack the whole nut back open.
It was more akin to a nunc-pro-tunc, dealt with the form using the 95 versus the 93 or vice versa.
Correct.
To show that he wasn't qualified.
Right. It was almost a clerical outing of this is what you would have got, but that doesn't really matter, but we still tell you what you would have got under the new sentencing guidelines because that's what the statute called for. So in looking at this case, my best summary of what's going on here is that Mr. Bailey is sort of being bounced between the sentencing provisions for pre-sentence guidelines offenses under 21-4603, and then the post-sentencing guidelines rules for restitution, which are under 22-3424, and also the rule that for pre-sentencing guidelines offenses, restitution cannot be collected until you were released on parole, because that's when the order was actually entered. Everything up until that point was just an advisory calculation by the district court who had heard and seen the evidence that gives the parole board a number so that if you eventually get parole, the parole board can impose that number or whatever variable it saw fit by the time you got to parole. But under sentencing guidelines cases, restitution is collectible immediately. So since 1993, everyone who came through on a post-guideline sentence has had restitution that's collectible immediately, which leads to the bureaucratic conundrum that Mr. Bailey sort of finds himself in, because he is now trapped between not only differences in pre and post law and what the court actually ordered, but the bureaucratic policies between the district court's collections actions, KDOC's rules for garnishing and saving inmate trust account monies, and then the actual collections agency contracted by the district court. That's how we get to this mess that it is, and which is why I think we need to reverse or remand, because there is a substantial issue of fact and law as to how these all play together, because the fact that we can tell is that somebody's collecting restitution from Mr. Bailey's trust account at the KDOC. They are taking payments from KDOC and cashing them in district court and sending out restitution checks, which should not be happening because since he has a pre-Kansas sentencing guidelines order, there is no restitution order yet because there's no parole yet.
Counsel, did you raise that argument below?
There was no arguments below. It was a pro se motion that the defendant filed. He did focus on dormancy. I know that's sort of foreclosed by the Alderson case because he's right. The court's right in Alderson. There is no judgment. But in his pro se motion, his complaint is that people are taking my money. I want my money back that they took from me already. It's not well worded as a pro se motion, but that is what's happening.
But the argument that it's not subject to collection prior to parole is being asserted for the first time on appeal. Would you concede that?
I would concede that because the pro se motion did not allege that specifically. But I think that there is a clerical error that segues into what the court can consider on the first time on appeal under 3504. In going through the records on volume 1, page 17, there is a single line entry in the record of action for the case that says restitution ordered, and it increases the amount from $1,500 some dollars to $37,000. That happened on September 14th, 2012. And then from there, they've been pulling more and more payments from his trust account. There's no paper order. There's no judge's signature. We don't know if a clerk entered this. We don't know if the collections people called up and said, how much does this guy owe? Because we caught this case when...
And the date was 2012?
2012, September 14th, 2012, which goes to the state's res judicata argument because he has all his prior motions to correct a legal sentence predated that increase in restitution. So it really is, it's a mess, is really what it is.
One other sort of big picture question, and this might sort of take you, question from left field, as it were, but are matters of restitution, the matters that you're raising now, are they civil or criminal? Do we even have jurisdiction given the statute that directs that all criminal appeals in cases like this come directly to this court? Does that give us jurisdiction over what's really, in effect, a civil claim on restitution?
Well, it's sort of a hybrid issue. So I think it kind of goes back to the point that Mr. Ney made. There's some inherent authority of the court to review its orders. And in this case, our belief is that if we went back and had factual findings that the court's order is being misused to collect monies that are not owed, and probably an extra 20% to the collection agency. So I think there's an inherent authority to make sure that the court's orders are not being abused.
Even if there was an inherent authority, why wouldn't that be an appeal taken to the Court of Appeals rather than to this court?
To be honest, I thought we had docketed in the Court of Appeals. I was surprised when the notice came back that the Supreme Court had taken the case. I think I tried to docket in the Court of Appeals, but it's a murder case. So I think that because it's a life sentence, it got
That's the
kicked up
question,
here.
is what is the jurisdictional foundation that this case rests upon? Is it that statute that requires that all appeals in criminal cases for murder convictions come to this court? Or is it something else?
I think that, again, this is where we're kind of trapped in this bounce between old law and new law because restitution is part of sentence for the last 25 years. Except restitution sort of isn't part of this sentence yet until he's on parole. And if he was on parole, it'd certainly be part of his sentence. So I guess my answer is I don't have a great answer, but I think that it's appropriate for the court to consider because of the life sentence and the other rules that restitution is part of sentencing, and that you do have to at least give the advisory calculation at the time of the life sentence. But that's sort of the best answer I have because I'm not as familiar with pre-1993 law as I am with current law, just because I wasn't practicing law back then. So that's sort of the crux of my argument is that we have this line item that creates an order that apparently is being collected on. And the court should have looked at this file where it can see that money is being collected, the defendant alleges money is being collected, and should have ordered a hearing with counsel so that this could have gotten untangled at the district court level. Because Alderson is clear on pre-Kansas sentencing guideline offenses, there is no restitution order yet they're taking his money. And that is, we don't know how. There's not a civil case filed in Johnson County to allow a garnishment. I don't know if this is just a contact to the Kansas Department of Corrections that says, we believe he owes this money to the district court, and they go okay and start garnishing his inmate trust account. So there's a lot of factual issues that I think support that this needs to be reversed or remanded for further hearing, because we do have substantial issues of fact just to figure out how this money is being taken from the defendant to satisfy a restitution order that in 1993 they just did an advisory calculation, and there is no restitution order by law because he's not on parole yet.
Are you abandoning your arguments with respect to any illegal sentence?
I would ask the court to consider those on the brief. I acknowledge that Keel sort of eliminates those arguments, but based on my client's directives, I just asked the court to consider.
And I understand that, but that circles back to the previous point, which is without a vehicle to put the issue that you really want us to look at in front of us, how do we get to it? We no longer have the substantive grounds to consider the sentence illegal. The argument that you're advancing now wasn't raised below, and arguably it's substantively it's a civil issue. I just help me, if we wanted to reach the issue, if we were compelled by your argument and convinced by it, how do we, what vehicle can we use? I just don't see one procedurally in the case.
I think you can actually use the second subsection of 223504 that we never use. That this is a clerical error of some kind that has led to this. The second subsection of 223504 is still part of 223504. It's still part of correcting an illegal sentence, even if it's not going to criminal history or any of those issues.
And if I'm seduced by that argument, can you help me by pointing me directly to the clerical error that you're alleging occurred?
Well, that's part of my problem. I believe the clerical error is this line item entry from 2012. That somehow that got entered as an order and that trickled out into this.
How is that a clerical error, though? I mean, it might be a substantive error, but that's not like a typo, is it?
Judge, honestly, and this is part of why I think we need to go back for factual findings, I suspect that this had something to do with changing computer systems from the DOS version of GEMS and implementing eFlex and backscanning old files. I think that
a kind of a cut and paste type error.
It could be a cut and paste type error.
Maybe it belonged in another case.
It could. Well, the number matches the advisory number, so they pulled it out of this case. But how it got entered in that particular box, maybe of the computer system, that's why I think we need to go back because something's wrong.
You're saying there's no corresponding court order.
No,
that would make that a judgment. In fact, the district court here said that it couldn't release a restitution because there was no enforceable judgment of restitution.
Correct.
But there's ostensibly no judgment, but the court documents indicate that there's a $37,000 restitution judgment.
Correct.
And that's what you're saying is the clerical error. It shouldn't be documented as a restitution judgment until parole.
Right. I think that the system couldn't handle an advisory number, so they just plug the number into the restitution box, and somehow that is turned into an order, even though there is no paper order. And the judge was very clear at the time of resentencing that this is an advisory calculation. So I think that,
in essence, there wasn't a box to check for a pre-guidelines restitution advisory number.
Correct, because I just don't know that there's that many of these anymore.
And that was not asserted below. in your client's pro se motion or arguments, if there were
No,
arguments?
my client's pro se motion focused on the fact that he thought it was dormant, and so he should get all his money
So,
back that had been taken.
What
But
we
it-
have, it seems to me, but correct me if I'm wrong, is you're advancing a new argument that the sentence is illegal, which can be made at any time, and asking us to remand for factual findings on that claim.
Essentially, yes. It looks like my client can't figure this out on his own from KDOC, and I think I finally found the source of the problem, but he wasn't able to plead it specifically as a pro se litigant. And since he didn't have the advantage of counsel to look at this in the district court, we couldn't untangle it down there. So that's why I'm asking this court to send
But
us
you
back.
have a document that's on file that purports to show there's a restitution judgment of $37,000.
Correct.
And we have, excuse me, Counselor, we have a court that ordered there is no enforceable judgment of restitution.
Yes.
And so why don't we have a non-pro-tunc circumstance that the record needs to be corrected to reflect what the judge ruled in this case?
That could be another way to fix the problem.
If that did happen, and if that, what you're alleging is a clerical error, is removed, what happens? Do you know?
What happens is I think that my client would have to civilly go after the collections folks and KDOC to get his money back in a separate
So
civil
two
suit.
things might happen. One, your hope would be at least that the collections would cease,
Correct.
and then secondly, your client would have a civil claim to try to recoup monies that he would at least allege were wrongfully taken.
Correct.
Okay.
And that's all the time I have unless there's other questions.
Thank you, counsel.
May it please the court, the state appears by Stephen Obermeyer. I'm here because I am familiar with pre-1993 law, and as the court can tell from the statement of facts, I've been losing appeals since 1992 and 1998 on this case. But I think I should win this time because I don't see that as a clerical error. The argument that it's a motion to correct sentence is a substantial issue of law related to the statutory execution of his sentence, i.e. restitution. I don't think that's a motion to correct sentence issue that brings us before the Kansas Supreme Court.
But in this case, didn't the district court summarily denied the motion for release of restitution, finding that there was no enforceable judgment of restitution, therefore the judgment could not become dormant? And if there is no judgment of restitution, why, number one, why is it listed on the court records as a judgment? And number two, what is the authority to collect on it out of the trust account?
As to both of those, I don't know why it's listed that way or what the authority is. And it's not to say that there's not some remedy for the defendant. I'm just saying it's not a motion to correct sentence.
Your argument would be that the remedy is a civil remedy, and it ought to be pursued with a civil claim, I presume.
Yes.
This argument about a clerical error, can you assume for me for a second that it is a clerical error? Is it a clerical error in the court's order or the sentence? In other words, could it be even corrected via non-pro-tunc?
And to answer Justice Johnson's question about non-pro-tunc, the journal entry of sentencing says it's an advisory finding
Right.
for the benefit
So
of
this
the
error,
Kansas
if it is an error, is I guess what I could characterize as a bureaucratic error in the system in DOC system. Is that right?
Yes, I think that'd be a fair characterization, but there was nothing incorrect.
So it might be wrong, but it's at least arguably a wrong that can't be corrected via a motion to correct the illegal sentence.
Correct. Because I don't think the district court and then this court on life sentences appeals should be the forum for all of the defendant's post-conviction complaints about restitution or what have you. The sentence imposed in 1993, I think, when the resentencing was ordered, there's nothing incorrect about that, and that's what I take the motion to correct sentence, which I think is a strange statutory creature anyway. But what I take that to mean is if there's an error in the sentence, and it's definitely not a clerical error.
Can I just ask a really practical question? Do you know, and if you do know, do you agree with what defense counsel said, that money is improperly being taken from his trust account?
I think she added something to the record that indicated that was the case.
And
so.
but you wouldn't contest that it's not supposed to be being taken. In fact, that's your position in the case, right?
Correct, because
So this is my very practical.
okay.
Short of further litigation, why can't this be fixed? I mean, we may not have the power to fix it.
Right. I think it's something that can be fixed. I'm just saying it's not the stuff of which motions to correct sentence.
It strikes me that it ought to be something that can be fixed, short of civil litigation as well. Maybe you don't have the power to do that.
Well,
and I recognize that's a comment outside the
right,
confines of
and
the
I don't know
case.
if the issue's with the Department of Corrections or where the issue is, and you have your difference between 1501s, which is in the file in the county where the inmate's residing, versus 1507s, which go back to the sentencing courts.
Right.
Right. I think there would be something.
What? I mean, Mr. Bailey's sitting there. What can he do in this situation other than do what he did? What can he do?
Well, the civil action of going after maybe a 1501 or going after KDOC or something, but it's not a incorrect sentence that was imposed. This is all I'm saying on that. And
this line that switches it from 1,500 to 37,000, where does it appear? There was this distinction between a bureaucratic error or some kind of court error. It's in the record of action in the district court, or is it someplace else? Or do you know?
I would defer to Ms. Zygtema as to where that
Record of
came
action.
in.
Thank you.
But that's all I had on that.
And who maintains the record of action?
I'm assuming the clerk of the district court.
And if we have a judge that made an order and we have knowledge that there are incorrect records of action that don't comport with the court's order and judgment, why can't that be fixed by you or by the judge or someone? If we know something's wrong, why don't we fix it instead of making someone that's incarcerated jump through the hoops and try to figure out what they have to do to fix someone's mistake?
If it is, yes, if it's an incorrect order, it could be fixed. And maybe that's what you were asking about the nut pro tunc, because we don't know where this wild card order came in. But I'm was addressing the sentencing and resentencing back in the 90s, that those were correct and should not be reconsidered. That's all I had, unless the court has any other questions. Thank you.
Counsel, you reserve 3 minutes.
I don't really have much. There's some practical things that the court may not be aware of, is that KDOC maintains 3 accounts for each inmate: a mandatory savings, a forced savings, and then a cash account, which is what they can buy commissary stuff out of or whatever they want. Those forced savings and mandatory savings accounts draw from their wages, and then they pay out the garnishments and all the rest of it. The client has no control. He's not directing these payments. They're being taken from him. So from a practical matter, it's a problem, and he is, while he has been here many a time, he is a pro se litigant that's not really experienced in collections law. So we're just asking the court to send us back to the district court level so that we can do something to fix him and that he can have an attorney assist him in fixing this, because otherwise, as a civil litigant, he's gonna have to go up against a collections agency and the district court clerk's office all by himself. This is sort of the only way he can get any help. So we'd ask the court to send us back for further hearing.
The court will take this matter under advisement.